it goes right to the top of the tree, because there's cases on this every minute nearly at the moment. Vicarious liability, basically we'll go through it now in a minute, but essentially what you talk about with vicarious liability is the circumstances where one party can be made liable, strictly liable, for the torts committed by another. Okay, so the first thing with vicarious liability we'll see, it involves strict liability. For the first time in going through the course, we are dealing with a type of liability which is different from fault. All the topics we studied so far involved fault or blame, a standard of care that had not been met, usually a reasonable standard of care. Strict liability is no fault liability. You are liable regardless of whether you took reasonable care or not. So strict liability goes against the grain of tort law generally. Tort law has got this moral element to it that you shouldn't be held to blame unless you were in some way at fault, unless it could be proven there was something you could have or should have done to have prevented the harm. You won't be held liable. So negligence is predicated on that idea. You should have done this. A normal person would have done this. If you had acted like a normal person, then this injury would never have happened. That's fault liability. Strict liability is you're to blame. End of story. So vicarious liability goes against the grain very much. And so basically where it most commonly arises, although it doesn't have to, where it most commonly arises is a situation where you have an employer who hires an employee to do a particular job, and the employee, when doing that job, injures the plaintiff. Now, in relation to a claim here, the plaintiff can obviously sue the wrongdoer, the employee, directly in negligence, and this would be primary liability. And if the plaintiff sued the employee who injured them in negligence, it's your standard negligence claim. You would have to prove fault here if you were the plaintiff suing the employee. However, under vicarious liability, there are certain circumstances where the plaintiff can sue the employer under vicarious liability for the wrongdoing of that employer's employee which has injured the plaintiff. The beauty of vicarious liability from the plaintiff's point of view is that if you can establish vicarious liability, then liability is strict. You don't have to prove fault. It doesn't matter if the employer took all reasonable care to have prevented the accident. If you establish vicarious liability, then the employer has to pay the compensation to the plaintiff. That employer, of course, could turn around and sue that employee and get an indemnity from the employee. Not usually worth it. The employee's obviously been sacked, doesn't have any money. But theoretically, plaintiff sues the employer pays compensation, employer could sue the employee and receive that compensation returned. Plaintiff has to choose one or the other. Cannot sue the employer and the employee. Has to make a decision. Now, because vicarious liability is a form of strict liability, it puts the employer in a very invidious position. Basically, what the law is saying to an employer is, we don't care how careful you were. If vicarious liability applies, you have to pay compensation to the plaintiff. So the employer feels very much aggrieved by vicarious liability because he's saying, it's impossible for me to avoid it. Because even if I take all reasonable care, the strict nature of vicarious liability means that I'm paying compensation. So that notion, it doesn't fit well or sit well within traditional tort principles. So vicarious liability, because it's different from general negligence, has to be specially justified. There has to be a special reason why we recognize vicarious liability. And we'll see there's various theories for why vicarious liability exists. And it's important that you're familiar with the theories, because sometimes the cases and the decisions from the judges aren't always clear. But at least if you have an understanding of the rationale, the purpose of vicarious liability, it might help make sense of the cases. In relation to vicarious liability, as I said, it's come up in the last two papers. It's typically vicarious liability, if you're looking at it in broad brushstrokes, it is once every 2 papers, once every 3 papers type question. It's come up in the last 2 successive papers. So, is it going to come up 3 papers in a row? That goes against it. What goes in its favor is, as I said, I've handed you out a note there, which is up on Moodle as well. There's been 5 High Court Court of Appeal decisions in the UK since July. in vicarious liability. So it's a hugely topical area. The last time it came up anyway, we got here October 2017, question 3, the last paper. Josephine was manager of the service department for Porcupine Garages Limited. Early one day, Des left his car, a top-of-the-range Rolls Royce, in for a service and said that he would return around 5 p.m. to collect the vehicle. At around 4:50 p.m, Des telephoned the garage to say that he was running late, but that he would be there before 6 p.m. at the latest. As the garage closed at 5 p.m, Josephine decided she would stay on afterwards until Des came to collect his car. Everyone else had left by 5:15 p.m. Josephine waited until after 6 p.m. There was no sign of Des, nor had he called to say that he would be even later or was not coming at all. Josephine decided that she had waited long enough and would have to go home. However, she realised that Des's car was in the front parking area. She was also aware that previously some of the cars parked there had been damaged by vandals, as the garage was not located in a very safe neighbourhood. Concerned about protecting Des's car, she considered moving it to the enclosed service bay, but by now that area had been fully alarmed and she did not want to call the alarm company and reset it. Josephine decided that she would leave her own car in the forecourt and take Des's car home, where it would be secure in the driveway of her house in a safe neighbourhood. She would then return with it early in the morning and no one would be the wiser. She knew this was against company policy but considered it to be a wiser course of action. Unfortunately, when she parked Des's car in her driveway, she forgot to put on the alarm and the interior of the car was vandalised during the night. Advise Porcupine Limited in tort for the actions of Josephine. So once again, you know this is the crucial part of all your problem questions in tort, the last line. Know the relationships that you're dealing with and their relationship to the facts of the question. Here you can see clearly you're advising Porcupine for the actions of